Hello everyone, my name is Zoe Gunari and I'm here to give you a brief overview of my module called Money Laundering and Corporate Misconduct. In this presentation, I'm going to tell you how the module is going to be taught, what topics it will cover, and finally, how it will be assessed. Now, first things first, Money Laundering and Corporate Misconduct is a module that runs in the first semester of your degree and carries 20 credits. I am the sole lecturer on this module, which is taught over 10 two-hour in-person sessions that comprise both lectures and seminars. You will also have the benefit of 2 one-hour sessions where you can drop in on an optional basis and ask questions to consolidate your grasp of the curriculum up to that point. Now let's talk about what money laundering and corporate misconduct is going to be about. Now, the aim of this module is to provide a detailed examination of the legal rules on financial crime and specifically on money laundering. And we're going to examine how those rules apply to the world of corporate misconduct, namely in circumstances where the accused is a corporation. We will be using the United Kingdom as a prime example, but there is also a significant international dimension to this module. This is because we will be examining in some detail the international community's rules on money laundering and how those rules interact with and shape the rules here in the UK. From this, our international students would be able to extrapolate how we take the international community's rules and apply them on a domestic level. Now let's consider the topics we will be generally examining under money laundering and corporate misconduct. We will be doing this in 2 parts. In the very first part of the module, we will be examining the domestic and international legal rules that have been designed to prevent the use of the financial system for laundering the proceeds of crime. In this context, we will be looking at the types of activity that could raise the suspicions of enforcement authorities. And in that context, we will then be looking at the work and powers of the relevant enforcement authorities, the most important of which here in the United Kingdom is the National Crime Agency. Now, continuing on in this context, we will be examining the law applicable to various practices in the context of suspicious activities such as insider trading and market abuse, and we will be paying special attention to similar rules governing the banking sector as well as the type of liability that banks may face as a result. So, in other words, the very first part of the module is to examine the rules that have been designed to prevent the financial system from being used for the purposes of laundering the proceeds of various crimes, such as insider trading, such as corporate misconduct, such as market abuse, and so on. Having said that, in the second part of the module, we will be taking that understanding and applying it into the world of corporate misconduct. Specifically, we will be looking at what happens in real life when a corporation is now accused of crimes, including money laundering and so on. We're going to look at how we charge and how we prosecute corporations for financial or white-collar crimes, and we will also examine how we go about enforcing those rules without resorting to litigation. Now, in order to demonstrate how all this works in the world of corporate misconduct, we're going to look at corporate bribery as a case study of a corporate-specific financial crime. This is because bribery is something that is an activity that is ubiquitous no matter what the type of white-collar crime a corporation might be engaged in. So it doesn't matter whether you're talking about insider trading, market abuse, and so on. bribery is going to be somehow involved in all of this. Now, instances of bribery will always involve instances of money laundering, and therefore we can see that bribery itself has a very wide-reaching effect for the financial sector as a whole, but also for society at large, because of the ability that bribery has to promulgate systemic corruption, not within an industry itself, but an entire economy. So, now we've looked at very briefly the topics that we will be examining through the money laundering and corporate misconduct module. Let's see how the module is going to be assessed. Now, the module will be assessed in two parts, namely through an exam and a piece of coursework. Each part of the assessment will make up 50% of the final mark. Now, the exam will be taken in person and is made up exclusively of multiple choice questions that will be applied to given problem scenarios. The coursework, on the other hand, consists of an essay, the word limit for which is 1,500 words. Finally, you will be able to test your knowledge and consolidate your understanding of the material prior to the summative assessment through various multiple-choice question tests that will be set at key points during the curriculum and its delivery. Now, this concludes my presentation, but if you have any questions, please do not hesitate to contact me at this email address. Thank you.